I appear for the appellants, my lord. In serial number 15.
15, yes.
My lords, I request for 1 week's time, my lords. Senior counsel is has some difficulty.
Request of the learned counsel appearing for the appellant. Yes, next.
Serial number 18.
Much obliged, my lords.
Serial number 18, my lord, Your Worship, may have it kindly next week.
Request of the learned counsel appearing for the appellant.
Serial number 25, my lord. Appearing for the
19
appellant.
some mention.
Number 19, any mentioning, sir? 19.
In serial number 19, your lords, I appear for the appellant in this matter.
Yes.
I need to take instructions from the claimant regarding this settlement part, your lords. As my learned friend is mentioning before this court, I'll make a submission
There is a
accordingly.
mediation center report. Yes. You want time?
I short accommodation, your lords.
Yes. Learned counsel
Your Lordship, serial number 14.
appellant.
Your Lordship, may kindly, my lord.
To get the
Lordship,
instruction
for the appellant, serial number 14.
is the matter.
Your Lordship, may kindly, my lord. Serial number 24, my lord. In this case, I am appearing for the appellant, my lord.
Wait, 1 minute, sir. Serial number 22, any adjournment?
Serial number 19, my lord.
19 adjourned by next week, sir.
Serial number 14, Your Lordship.
50, your worship.
Sir, one by one, sir, please.
Next.
Your Lordship, serial number 14.
23 to 26, any adjournment?
Serial number
25.
Serial number 24. In this case, I am appearing for the appellant, my lord. This matter was heard by their lordship in different combination. Thereafter, it was released from the party. Therefore, I require 2 weeks time, my lord. I have to re-argue the matter. I have informed the respondent counsel also, my lord.
That's I appear for respondent ESI Corporation, my lords. It was posted for judgment.
Now, whether both of you are ready to argue the matter or
I pray for time, my lord. I pray for time, my lord.
Your Lordship, serial number
is
14.
the
for the
matter.
appellant.
Week of the next at the request of the learned counsel appearing for the appellant.
Serial number 25, my lord.
Yes.
Appearing for the appellant. We
And for the
please ask
respondent,
for
my lord.
time, my lord, because senior is not available to argue right now.
No objection. my lord.
At the request of the learned counsel for the appellant.
Serial number 26, my lord. Serial number 26. sir.
Then what remains for us? What can we do here if we adjourn all the matters?
Serial
The
number
entire list gets collapsed. So what is the urgency in the matter? Only if there is any urgency, we can adjourn the matter. Not as a usual, casually, we cannot adjourn the matter like this. What remains for us? The entire list gets collapsed.
26, my lord. I am for the appellant, my lord. Today some
We will
personal
not adjourn
inconvenience.
any matter, sir. We will not adjourn any matter.
For posting, serial number
Serial
31.
number 26, my
At
lord.
least some matters should be there for us to hear.
Number one submission, lord. In serial number
No
26, my
adjournment,
lord.
sir. No adjournment in any other matters.
No, my lord. I filed wakala for respondent number 1 and 2, my lord. It's not.
Sorry, we will not adjourn any other matter.
Memo for posting, serial number 31.
I appear
Current
for
number is
respondent number 1, my lord. With your lordship's kind permission, my lord. I'm sorry, I have to make one mention. My lord, the batch of petitions, my lord, which has been allowed by the learned single judge, around 2,000 matters. The matter pertaining to regularization. And now for the last 8 months, salary has not been paid. They have put in 18 years, 15 years. We filed an application, my lord, to at least to pay the minimum wages. On 24/1/2022, memo has been filed. And meanwhile, my lord, we had the benefit of interim order, but there is a stay of the judgment. We filed 2 applications. One is for status, another is for minimum wage notification. The salary has to be paid. Those applications may be put up. The totally, my lord, His Lordship Justice Krishna Dikshit directed a scheme to be framed. There are totally 3,096 are there.
In which matter you are making the mention, sir? Serial number 31, MF
No.
6855.
No, my lord.
31, my lord, my learned friend is not making
This is
submission.
a fresh matter.
Making a fresh matter.
Where a memo has been already filed, and on 24/1/2022.
The matter has to be listed before the court now as per the recent procedure we are following.
No, 24 January, we filed a memo, my lord.
It will be listed, then we will consider it, sir.
It's not listed, my lord. Within
You
5,
can request the instructing counsel to send a mail today.
please, my lord. Please, my lord.
31,
I
Parameshwaran.
appear to respond.
Lords, in 31, my lords, the respondent has for posting. However, in the last date of hearing, in fact, I filed an application by the memo for retirement. This court has accepted my
Now, who has filed this memo?
order for a
I
notice to the
filed this
parties.
memo, my lord. The
Anand.
matter is not yet admitted. Since it is a recovery matter filed under section 21.A. So therefore, my lord, that if the matter is heard and it can be disposed, therefore, with that intention, I put.
Yes.
My name may be deleted from memo for retirement has been accepted and the notice has been ordered to the appellant by this court on the last hearing.
Appellant is not served.
Appellant is not yet served.
Please, my lord, that after service it may.
Memo for posting is rejected at present, since the appellant is not duly served as directed by this court. 31/12/2021. Yes.
32, Devi Narasimhan.
Mr.
My lord,
KV
appearing for the appellant in this matter, my lord. My lord, the memo for posting has been filed by the counsel for the respondent, my lord.
R2 is not yet served. How can we hear the matter? Memo is rejected since the respondent is not, respondent number 2 is not yet duly served. Yes. Madam Geeta ji Menon. Pass out.
34,
Yes.
Notices was issued in this case. We had filed an application IR number 5 of 2021 seeking dispensation with the entire record of 250 respondents are there. But the normal judgment was not. Everyone has produced the same thing. What we are seeking before this office is only.
No, the memo is for posting.
Please, madam. Consider IR 5 of 2021.
For posting.
Please, madam. Memo is filed seeking posting of the matter to consider IR 5 of 2021, which is already filed before the court seeking dispensation for sending the entire records other than only memo and date.
No, what is the main matter?
Main matter pertaining to section 40, invoking of section 40 of the Stamp Act. In fact, written order is also given to the court. Only thing is, it's a bulky record, around 4,220 respondents are there. The cost of process would be more than around 8 lakhs. That is the reason we had sought dispensation of the entire record. Appeal memorandum.
It's the matter in the first week of March.
Basically, like that. But it's already in interim order. Extension of that. Yes.
My lord, appearing for the appellant in this matter, my lord. My lord, in this matter, my lord, the respondent corporation, my lord, at the present has sent a notice, my lord, stating that they would attach the property of the appellant company, my lord. My lord, there is a delay of around 95 days in this matter, my lords. The matter has not been admitted yet. My lords may kindly condone the delay, my lord.
Please, my lord.
Yes. Can you consider this IA? Shall we
Yes, my
condone it 95 days? Do you have any
I leave it to the honorable court, my lord.
What is on the merits of the case? Are you ready?
My lord, the
Not
date
today.
may be fixed.
Any other date you should have.
So today we can, you can argue the matter. Today we are not having much cases.
No, I'm not having the copies or the order copies. I've just requested the office to send those papers, my lord. Your lordship may have it next week, my lord.
Then let IO 1 of 2020 be listed on that day.
Please, my lord, a short date may be granted, my lord.
This is a matter. 18 February.
My lord, on 16th, my lord. Please.
Mr. Sidramaya. Mr. Pradeep B. Pradeep B.
ಇದು ಆ ಕಡೆ ಇಟ್ಕೊಳ್ಳಿ ಸ್ವಲ್ಪ.
Instance rejected. Is 4 weeks time granted to do the needful?
My lord, we are appearing for appealant, my lord. My lord, we have already filed for retirement, my lord, and also we have sent the notice to the appealant, my lord, with regard to this, because he is not responding. My lord, we have filed a memo, my lord, on 7/12/2021, along with the notice sent to the appealant, my lord, telling that we are retiring from the case, and he has acknowledged the same, my lord.
He has not made any other arrangement. We will dismiss the appeal. We will accept your memo for retirement. We will dismiss the appeal.
A notice may be sent to appealant.
In 2016 matter.
Please, ma'am.
Who is the respondent hearing?
My lord, the Deputy Director, Regional Office, my lord.
Is who appeared for the respondents before the ESI court? With Mr. Innocent Swami. Why should we send a notice, sir?
My lord, no, they have already sent, because they have deposited the amount, my lord, for interim stay. They have deposited the amount. Further, they are not responding to our any emails or any letters. Only for this letter they have responded, telling that they have accepted.
No, they are not the uneducated or illiterate.
No, my lord, they are the company, my lord.
Yes, company. So why a company should we? Why can we consider that they have not received any instructions from the company?
No,
they know consequences very well.
Please, my lord, please,
we will not accept this memo, or we will accept it and we will reject the MFA.
My lord, memo may be accepted, my lord. In one
Either
time notice,
we will accept your memo. We will dismiss the appeal.
No, one time in notice may be sent, my lord.
Sorry, sir, we will not send the notice. Why should we send the notice? He is not a rustic villager or illiterate person. This is regarding your professional fees and all. You have raised some grievance.
No, not responding at all, my lord.
That I have received on 21st November 21.
Please, my lord.
Postal acknowledgement.
Please,
We'll discuss the appeal, that's all.
Notice may be sent, my request.
We'll not issue notice.
My humble request, my lord, because they have
Not saying the
deposited.
request is rejected. If you want, we will grant you 2 weeks time, further time, or else we will accept. If you insist to accept the memo, we will accept the memo, but we will not issue notice. Yes, sir. What do you say?
No, we tried to contact them, my lord. This is the
Yes, learned counsel for the appellant has filed a memo seeking permission to retire from the case. Submitting that the appellant is not cooperating to conduct the case. The said memo is placed on record. Along with the letter dated 15 September 2021 and the postal acknowledgement filed before the court. Appellant is permitted to retire from the case since no arrangement is made by the appellant to engage any other counsel, and there is no representation on behalf of the appellant. Appeal stands dismissed for non-prosecution.
Yes, okay.
For the appellant, your lordship, a week time may be granted to do the needful, your lordship.
2 weeks time granted to do the needful.
So bless your lordship.
Two weeks time granted to do the needful.
My lordship, I am appearing for appellant in serial number 5, my lordship. Memo dated 3/3/2020 for service of notice, my lordship. On 11/2/2020, this honorable court permitted the take steps through courier and through email, my lordship.
Yes.
The petition is under section 10 of the Indian Divorce Act, my lordship.
Whether it is served.
Please, my lordship, through courier, it's sent my lordship on 26/2/2020. I filed my letter and the receipt of courier, my lordship, and through mail, my lordship. Respondent is residing in Saudi Arabia, my lordship.
Acknowledgement, madam, for having received. Where is the acknowledgement?
I have not filed the acknowledgement, my lordship. I sent through mail also, my lordship.
No, you have to file the acknowledgement for having served the copy on the other side.
My lordship, through mail it was sent, my lordship.
No, that is not suffice. Away service of notice.
Elevated agitke notice data.
Issue notice to appellant.
Please.
Time granted to do the needful. Even the second set is also not filed.
I am for the appellant, my lord.
Lords, the matter is already settled out of the court, Lords, but only the problem is, Lords, they have not issued the NOC, Lords. No clearance certificate they have to issue. That has not been issued.
On the last occasion, you
Yes,
submitted.
Lord, yes, Lord. The matter is already settled. The execution petition which was
We'll
filed by
close
the
it.
corporation have withdrawn.
Then we will close it.
My
Withdraw
Lord,
it.
only clearance certificate they have to issue. Once they issue the clearance certificate, I will file a memo, my Lords, with regard to very same.
Then on 14/1/2022, you made the same submission.
Yes, my Lord. Yes, my Lord. The corporation has not issued. The corporation has not issued the clearance certificate, my Lord. That is the only.
Not agenda matter like this, sir.
I'm sorry, my Lord. I'm sorry, my Lord. My learned friend is also there. My learned friend is also there.
Mr. Bipin Hegde.
Lord, Manjunath was appearing, the colleague of Mr. Bipin Hegde.
Mr. Bipin Hegde.
Once they issue clearance certificate, my Lords, I have no problem, Lords. I'll file a memo for withdrawal. My memo for withdrawal is also ready, my Lords. I've kept it ready. Once they issue clearance certificate, I'll file it, my Lords.
Learned counsel for the appellant yet further 6 time to report the settlement. Mr. Matter.
Very well. Please, oblige.
Straight.
Yes, my Lord. I represent the appellant, my Lord. My Lord, I filed the IA for amendment of the appeal in order to incorporate certain new facts and grounds, my Lord. On the last occasion, it was directed to the other side to file the objections. So they have taken considerable time and they have not filed any objections.
Appear for respond number 1, my Lord. It may be allowed.
By allowing this amendment, it will not cause any problem for them, my Lord. I am only incorporating on additional facts and grounds, my Lord.
Yes, what you say, learned counsel for the respondent number 1.
Appeal for respond number 1, my Lord. We have no objection, it may be allowed, my Lord.
Yes. Or the learned counsel appearing for both sides. This application, IA2 of 2020, is filed by the appellant under Order 6-7 CPC read with section 151. The permission to amend the appeal memorandum in order to bring out the subsequent development which took place after filing of this appeal. Learned counsel for the respondent has no objections. For R1, you are appearing for
R1.
R1. Who appears for R4? Jagannatha.
But
Who is contesting respondent here?
the contesting respondent R1 only.
R1.
The respondent number 1 has no objections.
Item number 1, please be ready and enable your camera.
Application. Having heard the learned counsel for the parties and perusing the material on record, that no prejudice would be passed to the other side. In knowing this application, since the same pertains to the subsequent developments, which took place the filing of the appeal. Hence, IA2 of 2020 is allowed. Appellant is permitted to carry out the amendment as sought for. Amended appeal memorandum shall be filed after serving The advance copies on the other side. Then Mr. Dharmapal.
My lords, I am appearing for appellants.
Yes.
14 days delay in filing the appeal. It's a enhancement of compensation under Workman Compensation Act. Kindly condoning the delay and issue notice to respondent.
Notice without issuing notice, how can we condone the delay, sir? Issue notice on A1 of 17 as well as on the main appeal. Serial number 11. There is some problem again. Find out another time.
Are the counsel able to view court proceedings?
Now, yes.
Yes, madam.
Yes, madam.
Serial number 11. Mr. Tyagaraj. And appears. This is the matter. 2017 matter. Yes, codify, whether they have attained majority now, let us see. Survey consideration. Years at the time. Yes. None of this. This is the matter in the second week of March.
I appear for respondent, Your Lordship. The appellant has filed application under section 12. It may be heard along with the main matter itself, Your Lordship. The Lordships kindly have it next week, any day. The main matter itself can be heard and disposed of.
Mr. Vishal Kumar. And appears for the appellant. Learned counsel for the respondent is present. Mr. Matter. In the third week of February.
Appearing for the appellant, my lord.
Appearing for the respondent.
Lords, I'm appearing for respondent number 2 to 4, my lords.
My lord, the proceedings arises, my lord.
No, we expressed our prima facie, our opinion.
Yes, my lord.
So, yes, Mr. Chandrasekhar.
He has given NOC, my lord.
For R9, I am appearing, my lord.
But Mr. Keshav Bhatt.
Yes, my lord. For R9, I am appearing. My lord, since your lordship posed me that question on the other day, I spoke to clients also. Since it has come from your lordship, my lord, if they are putting an end to the entire litigation here only, my lord, one house he is agreeable. I have persuaded him rather. One house, my lord, there are two houses, as my learned friend has said. One house he is agreeable to give it up.
Not one house, sir. Both the houses. In both the houses, sir, in that area, because what has been auctioned is rather more than what was required.
There is no much difference. And one under the Land Revenue Act, such a provision is not there like CPC. Secondly, there is no such much amount is not remaining there. It is not that exactly with mathematical precision. Some 8,000 was the excess after sale of the property.
Yes.
Now, my lord,
14 lakh 450 was the amount to due with 14% interest. What somewhat about 34 or some
31
was
lakh.
the amount. Was the amount to due?
30 lakh 11,278.
30 lakh 11,278. What's the amount?
And my lord, at that time, 10 lakh 45,000 paid by the JDRs were also not deducted.
that is deducted, my lord. That certificate DC is not entitled. My lord, the consumer form, he has not raised this ground anywhere. Let him point out anywhere, my lord, either in his appeal memorandum or in the writ petition. He cannot urge it for the first time, my lord, with that too without producing any material. My lord, it is something like a decree. The consumer forum sends the certificate to the deputy commissioner. He cannot go behind the decree. My lord, and for secondly, they have not paid it. The present petitioners, except obtaining a collusive decree, they have not paid anything. Therefore, that argument is not available to my learned friend at all. My lord, this is a concession since your lordship has said it. I understand, my lord, your lordship's mind, my lord, because only human. Hello. Getting. Am I audible, my lord? Repeatedly, some
Yes,
problem.
you are audible, sir. Yes, you are audible. Yes. Yes.
My lord, since your lordship has, my lord, expressed that opinion, my lord, on humanitarian grounds, actually, I persuaded him. But this is not a case, actually, my lord, where sympathy should also be shown. These are all, my lord, deliberately these acts are done. They are not genuine people at all. My lord, your lordship has seen how even after this sale, I mean, even after the attachment and all that, from repeatedly from several cooperative societies, they have obtained the
When
loan.
did you get the sale certificate, that the certificate issued by the state commission after recovery certificate after deducting this amount? Pass it on.
That is something like a decree. Consumer forum sends it. Deputy commissioner cannot give any deductions there. Nor such
Yes,
appeal.
deputy commissioner cannot give it. Is like a decree. He cannot amend it. He is only required to execute it. Execute it. That's all.
He has to recover that much amount and forward it to the deputy commissioner. That is what he has done.
Yes.
Page number 3.
Page number 3. Yes.
This is pertaining to the first case. This is addressed to the deputy commissioner by 804 itself. Kindly come to the next page, page 4. Principal amount in this case was 50,000.
Yes.
Interest from 1 month 2010 to 25 2010 date of sale. is 3,70,000. Cost is 1,000. Total is 7,50,000. Amount received before the state commission 1,10,000. The balance amount payable to company is 6,10,000. Similarly, in the 4 cases, in every case, this was sent to us. And this amount we are sending back to the consumer for the total amount. That they were.
Now, what would be the total amount as per these 4 certificates?
That is also there. In correspondence to the 9 itself, I will show them.
What is the total amount?
Total amount is. Government dated come to the memo filed by respondent number 9 dated 13/9/2021. That place number 3.
No, it comes to how much? 25,53,478.
Please, check is issued to the consumer from their encash. The balance amount check we are issued to the owners of the land. They are not encashed.
They are
Total
not-
amount was 34 lakhs.
They are not encashed.
They are not encashed. This fact is, in our records in the account which is maintained at dash is not shown as record. Whereas this.
Now, what is the total extent of land? 9 acres, 30, how many guntas?
37 cents. 9 acres, 37 cents. With the
Cents or guntas?
cents, my lord.
9 acres.
37 cents. My lord, may persuade my lord to take my synopsis, my lord, in which I have, my lord, in detail, my lord, stated. My lord, with the calculations, my lord, with the sub-registrar's valuation, my lord, I have carved out, my lord, what would be the, my lord, actual market value as
File
per
a
the.
separate synopsis.
Yes, my lord.
Both of us have filed, my lords.
On second, my lord, I have filed.
A synopsis.
Yes, my lord. There, my lord, at the first page, my lord, lands in dispute which are subject matter of auctions are 2/2/22, my lord, I had filed it. Advocate for the appellant, my lord.
Yes.
Lordships get it, my lord.
Yes.
My lord, there, my lord, I have stated, my lord, the. Please, my lord.
What about the synopsis filed by the respondent? Yes, sir.
My lord, there, my lord, I have stated the lands in dispute, my lord. How, my lord, the what it actually contains and what is the, my lord, valuation as per the, my lord, guidance value of the sub-registrar, my lord. My lord, it is not the actual market value, but my lord, guidance value of the sub-registrar, my lord, along with the application for additional evidence, I have produced, my lord, the guidance value, my lord, maintained by the sub-registrar. My lord, according to that, my lord, if the calculations were made, my lord, the valuation of this 9.37 acres of land would be, my lord, 62,08,875, my lord. My lord, at the survey number I have stated, my lord, then extent, then my rights of the parties to whom it was allotted, my lord, I have stated. Then the existing crop in the lands I have also stated in other column, my lord, and valuation as per the guidance value, my lord. My lord, the total valuation, my lord, actual market value and guidance value totally difference, my lord. It will be a large difference in that area because it, my lord, contains a reckoned plantation of 3,000 standing trees, my lord, which are yielding. My lord, then the residential value, my lord, I have stated 32 lakh. And my lord, total guidance value as per the land sold, my lord, would be 94,08,875, my lord. My lord, kindly appreciate in these lands, my lord, an area of 5.30 acres, my lord, was allotted to appellant number 2, who is not a partner of the firm, nor, my lord, she owes any liability, my lord, as against the decree obtained in the district consumer forum, my lord. My lord, this would be very relevant.
Yes.
My lord, there is disconnected, I feel, my lord.
Yes, yes.
My lord, out of the land sold, my lord, last 4 items of land, my lord. It was allotted to the share of Latamani, that is appellant number 2. My lord, an area of 5.30 acres of land, my lord, which was allotted to Latamani, Harsha and Nalinakshi were sold in the public auction, my lord. My lord, actual defaulters, my lord, Lordship may kindly see, respond number 2 to 4.
Yes.
My lord, they had, my lord, the other lands, and they, my lord, sell the lesser extent of land belonging to respond number 2 to 4, namely 1.64 acres pertaining to appellant number 1 and respond number 2. Then, my lord, 2.43 acres of respond number 2, who is Taranatha, my lord, who, my lord, admittedly is a JDR. I can't dispute that. But, my lord, Latamani, who is not at all related with the decree of the Consumer Forum, an area of 5.3 acres belonging to her has been sold.
0.3?
5.30, my lord, acres.
Yes.
That is last 4 items of land, my lord, in the chart.
Yes.
Therefore, my lord, kindly appreciate this aspect. A person who claims an independent right over the property, her land, my lord, to the extent of 5.30 acres were sold. Whereas, my lord, JDRs, my lord, who colludes with the revenue officials, my lord, to protect their right, my lord, minimum lands were sold belonging to them. My lord, 2.43 acres belonging to respond number 2, and my lord, 1.64 acres belonging to respond number 3 and appellant number 1. And my lord, the total valuation as per the guidance value, I have brought it to my lord's kind notice. My lord, it is nearly 1 crore rupees, my lord. My lord, then, my lord, in the
How many houses are there?
My lord, I have instructed that, my lord, one house is existing in the auctioned lands, and the other house is situated in the Kumki land belonging to this auctioned land, my lord. That is my instructions. My lord, then the other aspect I may bring to my lord, kind notice, my lord, section 162 of the Land Revenue Act, my lord, may take for a moment. Just, my lord, refresh my lord's kind memory.
Okay, sir.
Karnataka Land Revenue Act, my lord, 160 subclause 2, which speaks that, my lord, there should be a statement of account certified by the commissioner or the assistant commissioner, my lord, which is a conclusive evidence, my lord, what is the actual areas of land revenue. My lord, in the case on hand, there is no such certificate. Then, my lord, may I take section 173 for a moment, my lord. 173.
Yes.
There, my lord, it is equivalent to, my lord, provisions contained in the Code of Civil Procedure Court, my lord, which speaks, sale shall not be excessive, my lord. My lord, may I read for a moment, my lord, a short provision, section 173.
Yes.
The property to be sold, movable or immovable, under the provisions of this chapter, shall, as far as may be practicable, be proportionate to the amount of arrears of land revenue to be recovered and the expenses of attachment and sale. My lord, it specifically speaks, my lord, the sale should not be excessive, my lord. My lord, here kindly, my lord, the reasoning of the deputy, my lord, the deputy commissioner, for a moment, only one sentence I will bring to my lord's kind notice. At page, my lord, 68, my lord. Page 68 of writ appeal. There, my lord, third line onwards, my lord, 2 lines I shall be permitted to read, my lord. Page 68. My lord, gets it, my lord. When Nalina Finance is a family business, third line, my lord. And when the track records of Nalina Finance found to be very poor, and in spite of the above facts, if the respond number 9 had resorted for obtaining the valuation of the land and spent time to secure valuation certificate, in that case, the entire property would have been lost and it would have been in the hands of third parties. My lord, this is the reasoning. Deputy Commissioner admittedly, my lord, reasons that valuation of the properties were not done. But reasons, my lord, If valuation would have been done, it would have, my lord, taken away the entire property is the reasoning. Therefore, not making valuation does not, my lord, vitiates the auction proceeding is the one of the deputy commissioner, my lord. My lord, now kindly appreciate section 173 read with section 162 of the Land Revenue Act, which, my lord, mandates, my lord, there should be, my lord, a list of what is the actual areas of land, and section 173 mandates that the sale should not be excessive. My lord, unless they make a valuation of the land and unless they determine what is the actual amount due, my lord, putting the entire property of 9.37 acres of land, my lord, vitiates, and it is a material irregularity, my lord, while conducting the sale. My lord, which squarely falls under section 176 1A of the Land Revenue Act, my lord. My lord, my petition is under 176 1A of the Land Revenue Act. I, my lord, intend to, my lord, challenge the auction proceedings on the ground of material irregularity in conducting the sale. My lord, as I brought it to my kind notice, first material irregularity in conducting the sale is not, my lord, taking action under section 160 subclause 2. Then, my lord, not my lord, determining what is the actual land to be sold for areas of land revenue. That is 173, my lord. My lord, though, my lord, this is a